Maybe do it
So welcome everyone. It's great to see such a large turnout, and welcome to the first constitutional conversation for the 2020. Is it really 2020 already? It just I can't believe how fast things go by. But it's a. Well, maybe I should just talk loud. I didn't do anything different. Now you can hear me? So in any event, I hadn't even gotten to the substance, so it doesn't much matter. I was nattering on about 2020. It's my pleasure to introduce Jack Goldsmith and Bob Bauer for a conversation this evening. I'm not going to give their full resumes, but here's what you need to know. So Jack was a top lawyer, namely Assistant Attorney General in the Office of Legal Counsel. This is Jack Goldsmith, in the second Bush administration. Bob Bauer was the counsel to the Obama for President campaign, then was White House counsel, has been counsel to the Democratic National Committee, and is a partner at Perkins Coie Law Firm. Oh, no longer. He now has joined our academic ranks as teaching at NYU. I didn't know that until this very instant. But what's interesting about this is that they were top lawyers in a Republican and a Democratic administration. What's even more interesting about this is that they talk to each other. How about that? And now they're going to talk to us about what they've been talking to each other about, and specifically an agenda for reform in the years after Donald Trump is no longer with us to dominate every news with his tweets. So what I think is so great about this is that, so few people in this country today do talk to folks across the political lines. And when they do talk, they maybe argue. But what we're going to see tonight is that it's possible to talk across these political divides and to try to come together in some kind of constructive way to see how the country can be made a better place. So with that, let me please join me in welcoming Jack Goldsmith and Bob Bauer.
So thank you for coming tonight. The name of our book is After Trump, but I hope that you didn't come thinking that this was going to be a how-to manual to make it after Trump. The subtitle, as Michael said, is An Agenda for Reform. And the book, which we're still in the middle of writing, so we look forward to your comments. The book builds on two premises. One, that the Trump presidency and the way that Donald Trump has run the presidency reveals excesses in presidential authority and inadequate presidential accountability that we think demands reform along a number of dimensions. And we have 13 chapters in the book with 13 or so topics. I want to be clear that this problems of excessive presidential power and inadequate presidential accountability didn't begin with Donald Trump, obviously. The Obama administration, Republicans thought that President Obama engaged in hugely excessive exercises of presidential power with inadequate accountability. Certainly a lot of people thought that about George W. Bush as well. And this is a familiar trope. I mean, it's kind of an American tradition to claim that our presidents have excessive power. But we believe that Trump has revealed flaws in the presidency and the way it's structured that demand reform. The second premise is that there will be an after Trump, but obviously we don't think that our reforms have any chance of being adopted while Trump is still president. So these are reforms either for 21 or 2025. We're not sure when. But as Michael was suggesting, well, we do think that there will be a time when Trump has left the scene, maybe not Twitter, but left the presidency. When we're going to have a fundamental conversation in this country about the presidency, whether it's too powerful, how it's too powerful, and what should be done about it. And so the aim of our book is to kind of frame that debate, whether it happens next year or 4 years from now, and we might have to do another edition if it happens 4 years from now, we certainly will. We aim to kind of frame the debate about how to think about reforming the presidency. And we have a number of very concrete proposals, some of them technical, most of them technical, some of them controversial and non-obvious, some of them obvious. But for us, the actual reforms matter less than kind of setting the framework. And as Michael suggested, Bob and I have become friends. Bob worked in the White House. I worked in the Justice Department. He worked for President Obama. I worked for President Bush. But we have a lot of common ground. And we hope that a kind of tempered, informed, reasonable framework for understanding these issues will help in the reform debates we're going to be having. So what I'm going to do with about the next 7 or 8 minutes is just to talk about some of the challenges of the project, because there are many. And then Bob is going to sketch just some of the reform issues we're going to discuss. It's impossible for us to get into all the different reforms we're talking about. We're happy to talk about anything that we're, at this point, competent to talk about. We haven't worked everything out. We're about a third to a halfway finished with the book. Some reforms we haven't even begun writing about, for example, about the pardon power. Okay, so 3 basic guiding principles when thinking about reforming the presidency. And the first 2 maybe not be obvious. And these are contestable principles, but we believe them to be true. The first one is do no harm to the presidency. The American presidency is a very powerful institution. There's a reason why it's a powerful institution. The framers created a powerful presidency. They couldn't have imagined the contemporary presidency, but they created a powerful presidency. And presidential leadership and presidential power has been important for so many political and legal advances in this country. And basically, we need, in our judgment, a powerful presidency to make the government work and to make separation of powers work. And this is maybe not a popular view now, but I'll just remind you that it was the view, for example, of Arthur Schlesinger Jr. in his famous book in the 1970s, The Imperial Presidency. Schlesinger was quite clear about this, very clear. His job was not to chop down the presidency. He was a proponent of the heroic presidency. He wrote books about the importance of the presidency. His job was, he thought his task was to bring the presidency under proper constitutional constraints and to ensure that the presidency was adequately accountable. So we are not against a powerful presidency. That's the first point. We can talk more about that if you like. Second, as a general matter, our proposals eschew, we avoid radical constitutional surgery. I mean, you might think that after Trump we should just rethink the presidency entirely. And we should rethink Article 2 entirely. And I'll give you just one example that we reject. And that is, you might think, and again, we can talk about this in more detail, you might think that, for example, the notion that the Attorney General and the Office of Legal Counsel exercising delegated authority, that the opinions, very controversial. This is the job I held in the Bush administration. It's grown more controversial because its opinions are sometimes thought to be giving excessive deference to presidential power. Some people see OLC as the lackey of the president. As a general matter, there are lots of ways you can organize legal advice within the presidency, and OLC doesn't necessarily have to have an exalted role. But one thing we believe is sacrosanct under the current Constitution, and that is that the executive power is vested in the president. The president has a duty to faithfully execute the law. And what those powers mean is that the president gets ultimate interpretive power of the law for the executive branch. And when the Attorney General or OLC exercises that power, they're just exercising power that the Constitution gives to the president. And we don't propose to change that. We propose to operate within that constitutional framework. There was actually a movement after Watergate. There were weeks of hearings about, and Sam Ervin proposed to make the Attorney General an independent agency, for example. And there were many reasons why the Commission of Wisdom came to be that was a bad idea. But one was that it was unconstitutional, the scholars in the 70s thought, and that's basically our view. So we're not in this book proposing radical constitutional surgery for the presidency. The third, though, is that we do think there's a very serious danger of doing too little. And on some things, it's quite possible that when Trump has gone from the scene, so much of his behavior, so much of his norm-breaking behavior is self-defeating. I mean, in part, it's empowering because he's shameless, and shamelessness, it turns out, is very empowering in the presidency. But so many things he does hurts himself, and there's maybe reason to think that a lot of his norm-breaking behavior won't be repeated by his successors because they haven't worked out in many respects terribly well for Trump. But we still think, for several reasons, that there's lots of room and need for reform. For one thing, it's clear to us that there's lots of areas of presidential regulation that just need reform, and we think that in a post-Trump world, there will be bipartisan support for such reform. Talking here mainly about presidential tax returns, mixing presidential business with private business, conflict of interest rules. These are areas that we originally talked about as low-hanging fruit of reform. We don't call it that anymore because it's actually complicated. But we think that this is a clear area where Trump has made clear in this area that the norms that govern presidential behavior, non-legal norms, are inadequate, and there needs to be legal regulation, and we propose a raft of such regulations. Second reason why we think reform is vital is it's not just the presidency that needs reform. It's not just the president, and it's not just the White House. A lot of what we talk about is presidential-White House relations. And also, there are other institutions in the executive branch that demand vital reform. And Trump is not the only problem here. The 4 Inspector General reports by Michael Horowitz have revealed that a lot of flaws in the way the FBI, and to some extent the Justice Department, investigate campaigns and investigate the president. And so one of our chapters is not about Trump, but about, in some sense, the reaction to Trump and the reaction by the FBI to the Hillary Clinton campaign. In general, there's terribly inadequate guidance and law and norms when it comes to opening up investigations on campaigns and on presidents. And a lot of the problems that we had, a lot of the controversy that surrounded that resulted from inadequate guidance that we think needs reform. And then we also think that there's this is not a subtle point, but norms are collapsing everywhere at the institutional level in government. It's likely to get worse. This is a paradox and a problem for our project, but we think that the Trumps of the world in some sense aren't going away. There's reason to think that future presidents that the populist impulse will be with us for a while, that we see this in some respects in the Democratic side of the campaign, that we'll see perhaps norm-breaking presidents who are less beholden to institutional restraints and traditional institutional restraints than past presidents who will be more aggressive in asserting executive power. We think this is very likely to happen, and we think that steps should be taken to anticipate that phenomenon. We might be wrong about that. Okay, I'm going to speak very quickly because I'm almost out of time for my 15 minutes. This is an impossible project. and with my academic hat on, we're making normative arguments that have so many foundational problems, I don't even know where to begin. And for the most part, we just shove those aside. And let me explain what I mean by that. So there are a whole bunch of problems, and these are complicated reform issues that we're talking about. Bob will go through some of the topics we're covering. But every reform proposal poses the danger of unintended consequences or self-defeating consequences. This is a feature of reform of the presidency. You try to do one thing and you end up making it worse. The famous example here is the Independent Counsel Statute in 1978 that was a response to the perceived need to have someone independent of the Justice Department to investigate and maybe prosecute crimes by high executive officials. It turned out to make things like the conventional wisdom by 1999 was that made things much, much worse. And that's always a danger, unanticipated and self-defeating consequences. To some extent, it's just a lack of information. You don't know what problems the future holds. You're focusing on past problems. You don't know what problem the future holds. That's an ever-present problem in what we're doing. Fundamental problem is that a lot of the reforms we propose depend vitally on who the next president is and what the Congress looks like. Now, the Congress is, along many dimensions, itself dysfunctional. We could have written a book about reforming the Congress. And maybe that's the place one should start. But we decided to write a book about the presidency. And so we are basically taking the dysfunctional Congress as we find it. And we don't have any exaggerated expectations that Congress will necessarily get its act together. Many of the reforms we propose can be implemented by the president. Many require Congress. But all I can say is that you never know. The 1970s, which is the last time we had a major reform of the presidency, unexpectedly, you went from a Congress that was very weak for a long time, that unexpectedly, through a kind of important election, rose up and was very reform-minded, and over 4 or 5 years enacted a raft of reforms that were very important for the next 50 years and were largely consequential. They weren't all successful, but they were successful. So we're just assuming away the problem of a dysfunctional Congress because we can't, or a politically inappropriately aligned Congress, we can't address every problem. Our reforms are for when and if there is a prudent president and or a Congress that, for a variety of reasons, can get its act together and pass what we think are needed reforms. Ultimately, it depends on the American people. And this is definitely something we can't reform. And the country is divided along so many lines, and there are so many structural reasons for it, and it seems to be fragmenting more by the day. And ultimately, the success of law and the success of norms, ultimately it depends on the American people and politics to work. And this is all moving in a bad direction. And a lot of our reforms depend ultimately, like all of law actually, on the ultimate support of the American people. And if the American people and members of the opposite party from the president aren't willing to step outside of their party role and to play a more institutional role, and if politics don't coalesce around certain action that exceeds norms and is unacceptable, then none of this is going to work, ultimately. But let me just say, and this is the last comment I'll make, there's been a lot more of that during the Trump years than we realize. It was a remarkable thing that in the face of Trump's barrage against Mueller and against his political appointees in the Justice Department and the FBI, that Mueller was able to complete his work and get his report out. And a lot of the reasons that happened is because Republicans in Congress, important Republicans in Congress, when Trump was on the verge of threatening to fire Mueller or to go too far in the Justice Department, they stepped in and made clear that that wasn't acceptable. So even in this era, it still happens. That's the kind of politics ultimately that all reform in this area depends on. We're not completely skeptical that that's possible, but only time will tell. That's the framework. Bob will talk about some of our reforms.
Thank you. So let me just emphasize that some of the reforms, I'm going to run through this very quickly. In our book, we attempt to identify what's really complicated and what we're proposing to do. We're not only not sanguine, as Jack pointed out, about how easy it will be to move some of these reforms. It will depend on the politics of the country and certainly who the next president or presidents are. But there are constitutional and all sorts of technical difficulties, at least with some of what we tried to do, some of what we're proposing to do. So I wanted to say I'm not going to go into all of that here. I just want to give you a flavor for some of the ways that we've been thinking about solving some of these problems, some of the directions that this kind of reform could conceivably take. And I also want to emphasize very quickly that in some cases, the reforms that we're proposing have a dual function. If we're talking about a statute, we may be looking to directly affect some kinds of behavior that we believe needs to be addressed by reform, but we're also looking to fortify what we think are failing norms. And of course, the whole conception of norms now has received so much attention in the Trump era. As Jack points out, there are ways to think about how these norms were under tremendous strain and beginning to crack in presidencies before Trump. But ultimately, the task of legal reform is very much bound up with attempting in some way to put new force in reforms that currently seem to be failing. And if we're correct that future presidents may see the advantage in very different ways to, if you will, traveling the same path that Donald Trump did, it's very important to try to bring those reforms, at least the ones that can still be salvaged, out of their current dilapidated condition and give them potentially a little bit of additional force. And so with those preliminary remarks, very quickly, and then we'll have an opportunity in the Q&A to talk more specifically about them, let's take the question of conflicts of interest. And in each one of these cases, what I think we're trying to do is to show it's a balanced approach. There are some things people might think it is the best way to proceed. They might think there's a reform, a silver bullet reform. We oftentimes do not think that's the case. And in light of what Jack has said about the presidency, sometimes we're really splitting the difference with reforms that are targeted to the presidency, but which we hope would not be so overdrawn that it would enfeeble the presidency the way the presidency we think needs to function in the constitutional order. Let's take conflicts of interest as an example. This president, in somewhat brazen fashion, has decided to maintain very active, complex business interests while running for president. I won't go through what we discuss in the book, but we try to give some background about this particular controversy and the ways in which it would not be correct to say, as his lawyer said in December of 2016, that he has been, quote, completely isolated from or completely removed from his business interests. There's reason to think that's not quite true. It's not quite the way one would describe it if one had all the facts at hand, or even the facts, by the way, that have appeared in the newspapers. So given that, we now have the possibility that people will come with significant wealth that pose serious dangers of conflict of interest and attempt both to have some ongoing involvement with their business, some supervisory relationship to their business, but at the same time run the executive branch. What is it that we can do? This is an issue that Congress has literally, other than the debate in the context of impeachment, the Congress has done very little to address over the last couple of years. Think about the absence of any hearings solely devoted to questions about whether or not there's an emoluments clause issue raised by the potential receipt of income from foreign sources into the president's business interests. So what do we suggest and what don't we suggest? We suggest, first of all, that the separation of the president from business interests while he or she holds office has to, in fact, be complete. No special briefings, whether from family members or other staff, no ability to go to a business interest down the street, as has apparently happened, and have the president check up with employees of a business interest like the Trump Hotel on how things are going. Absolute separation. But then the question is, if there's absolute separation, who will tell us what those business interests are? How do we identify what the president's business interests are? And the answer is through a requirement imposed on the businesses in which the president has an interest. Now, that's not uncommon. Under the federal lobbying laws, for example, as they're currently structured, members of Congress don't report who's been lobbying them. I mean, there's some, I'm overstating the case slightly, but that's largely true. The obligation falls on those who are spending the money to lobby the individual member of Congress. The conflict of interest is, in fact, identified through private sector disclosure. And so we say the same thing ought to happen here. A business that retains, that in fact the president has an interest in would be required to report them. Moreover, the president should not be able to do what Donald Trump has done, which is to say, listen, I'm willing to live off my wealth, which gives the president more interest in how his wealth is being managed, and I'm not taking a federal government salary. As a matter of fact, I'm going to reject the federal government salary, and I'm going to turn it over to the federal government to help reduce by whatever massive fraction of 1% the deficit is. Our view is that just as the President of the United States cannot decline Secret Service protection, the President should not be able to decline a salary. The President should be paid that salary. Now, the President may decide to give it away, in which case the President should not be able to receive a tax deduction. Or the President might decide to give it to the federal government, the way Trump has done or claimed to do, but the law would prohibit the federal government from accepting the contribution from the President of income declined from salaried sources, government salary. And the reason for that is to simply establish the presidency is a full-time job. And the president should be doing that job and only that job. And if the president only does that job and is not concerned with private wealth located elsewhere, it reduces the risk of conflict of interest, and it prevents the president from being able to argue that in some way he or she is ennobling the presidency by refusing to take government income as a measure of full-time commitment to the job. Now, what don't we provide? We do not agree that Congress should be able to mandate that the president divest his or her business holdings. We think there are huge problems with Congress assuming that it can essentially order the president to take specific actions of that kind with business holdings and interests. Nor do we favor a blind trust arrangement. And there's a different reason for that. Because a blind trust arrangement suggests that in some way the president of the United States ought to be able to park the wealth somewhere and say, since I don't know anything about it, you can't know anything about it. And so it defeats a larger transparency objective in the public at large. First of all, there's all sorts of complicated questions about what it means for a trust to be truly blind. Lyndon Johnson famously had a blind trust, and he had a separate set of telephones that couldn't be monitored by the government that he used to call his trustee and deliver investment instructions. If you put the right people in place, it may not be necessary for you to have granular conversations with your trustee. So we do not agree with a blind trust arrangement. So that gives you sort of a rough overview on financial conflict of interest. Very briefly, on taxes, the president has refused to turn his tax returns over. Congress has fought with him. The Democrats in the Ways and Means Committee in the House has been involved in a legal battle with the president over whether the House can, for investigative reasons, demand the president produce his tax returns. There are significant constitutional problems or issues with the House's position that will be litigated. Congress clearly can amend the current Ethics in Government Act, which requires public officials to do some personal financial disclosure in ranges, and require presidents and vice presidents to provide their tax returns and have them filed, for example, with the Office of Government Ethics for public release. We recommend that you take the matter straight to where you know your standing is constitutional, where the ground on which you're standing is constitutionally firm. A statute like that for all presidents across the board, regardless of whether there's any particular investigative interest in any one president's tax returns. All presidents should release their tax returns. And it is not commonly known that the Internal Revenue Service, currently by regulation, audits every president's tax returns. Under our proposal, presidential audit reports have to be made public. When they're completed, they have to be made public, and a copy has to be provided to the Congress for review by the Joint Committee on Taxation. And last but not least, we also believe that the requirement to produce tax returns ought to apply not just to the president and to the vice president, but to any members of their immediate family who are employed in senior executive branch positions or in the White House. That may sound targeted, but it in fact has a logic behind it that I think is salutary, and to the extent that it discourages presidents from staffing the government with family members, we're speaking here about yet another signal that this kind of legislative activity can send. I don't want to go on much longer. I'm trying to give you a flavor, but just to give you an idea, we have a very specific chapter devoted to a topic very much in the news. How do we break up or address political alliances that presidents might establish with foreign countries? Again, this seems targeted, but there's reasons we give in the chapter why we need to see this as an enduring concern that needs to be addressed in future administrations and not be solely a concern for this one. And it turns out the law on this is complicated, as Bob Mueller understood. He tried to consider whether, for example, if the Russians were able to provide, as they had apparently offered the president, opposition research on his opponent in the 2016 election, was that something of value that violated the federal campaign finance laws that prohibit foreign nationals from making contributions to candidates for public office? And Mueller concluded there were constitutional and technical problems with reading the campaign finance laws that way. We propose a reform to the campaign finance laws to address that issue, but we also talk about requirements that presidents and presidential campaigns should be obligated under law to notify law enforcement and the intelligence community in the event that a foreign nation contacts that campaign with the purpose of exploring some kind of mutual politically advantageous activity. And we have that would require in addition, in the event that that kind of undertaking proceeds, require a wholly new statute that we recommend that is actually addressed to something that goes beyond campaign finance, and that is precisely that kind of coordination between a foreign government and a presidential campaign for mutually beneficial electoral purposes that serve both the American campaign and the foreign government's interests. Last thing, I just want to mention two things very quickly. Jack mentioned that we have a chapter on the special counsel. This is something that needs to be addressed because we have a long history of trying to use special prosecutors, and then in that long experiment, court-supervised independent counsels in the 1990s that both parties threw up their hands over and decided should lapse after the Clinton impeachment episode concluded. We now know also that there are problems with the current statute, as evidenced by all the complications that Bob Mueller believed that he encountered in doing his job, that he described, by the way, in the report that he was issued, and also as evidenced by the conflicts between Bob Mueller and the Attorney General of the United States. And we propose to revamp that arrangement completely so there are clear lines of authority. On the one hand, the Attorney General does control legal interpretation of the Department of Justice. End of story. Does. And there's no question that that's the case, and we don't think that should change. On the other hand, we want to protect the independent counsel's fact-finding function because we think it's critical, and we think there's massive public expectation to support it, that an independent counsel who's looking at potential criminal activity of the president or the vice president or senior administration officials, but we're talking, of course, here specifically of the presidency, should be in a position unobstructed by the attorney general or the president to give a full factual accounting of what he or she found in the course of that investigation. It's a fact-finding exercise. That's what, in many respects, the independent counsel and special prosecutor ventures have become. They're also very much exercises in fact-finding in which the public wants to know the answer to the question, what happened here? What exactly happened? After which there's an argument, of course, about whether what happened contravenes any particular law or regulation. So just as we would protect the Attorney General on the legal side and the whole notion that Jack described of the president's control over law, so we would protect the independent counsel's ability to give a full accounting to the public of the facts. We also think that for a variety of reasons there need to be other measures taken to address the law as it currently stands, that the president can't be indicted for any crime while still in office. Among the proposals that have been circulating, and we adopt one of them and set it out, is a tolling statute that means that the president can't, if you will, run out the clock and let the statute of limitations save him or her throughout the period of the term. We also talk about war powers, particularly nuclear control, the question of just what kind of controls ought to be put on the president's sort of unfettered access to nuclear weaponry. And I think I'll leave it at that and just close by saying we even have a chapter on the presidency on the press. And it seems to me there's not a whole lot of direct statutory activity that you can engage in, but there is some significant steps that you can take, which include some norm-reinforcing actions to give the presidency some authority to do more, to give us a better assurance that the president and the press or the president does not hound the press, harass the press, intimidate the press, or interfere with its normal news-gathering function. So I'll stop right there.
We have about 25 minutes for questions, so if you just want to come to the mics, and we'll just rotate back and forth from the side.
It's very informative, and it's great to have the honor of your perspectives. I have a question. Have you considered anything that might have prevented Berkeley professor John Yu's torture memo during the Bush administration in your studies of the war powers and maybe the stovepiping of falsehoods through the sealed or classified agencies? As for electoral strategies, these all seem to be electoral strategies. I mean, you're criticizing flaws that have occurred, and so I'm not going to ask about whether it is or is not a how-to, but I think you touched on the absolutely correct point early in the conversation when you said reforming Congress is critical because we have the Citizens United thing that allows moneyed interests to select instead of the population to elect. So I would recommend the Amendment Act. I don't know, I think it's bit.ly, bit.ly/Amendment Act, or word. It was a 2003 proposal to, I don't know, fund PAC contributions by 99%, and several other possibilities there. The Constitutional Referenda Act of 2013. But please, on the torture memo and stovepiping.
Yeah. So wait, can I ask you a question?
Sure.
What do you mean by stovepiping?
Oh, well, like for example, we were told that these so-called bioweapons, mobile bioweapons factories turned out to be weather balloons for artillery, and there were no. Most of the hypothetical weapons of mass destruction were fabricated in order to provide the.
So the answer.
The Senate was told just shortly before voting that there were UAVs off of the Atlantic coast just before voting for the authorization of force. That was a terrible lie, and they knew that there were only like a few model airplanes with cameras on them. That was.
So there have been lots of problems in the executive branch over the decades, and the answer to your question is we don't address either one of those issues. We don't think that they are the most salient right now. Neither one of those issues have been issues that have been highlighted by Trump. Those are the ones we're mostly focusing on.
Aren't there professional responsibility ethics that would prevent somebody like Professor Yu from contravening the medical research, literature reviews?
That happened 18 years ago, and there's been a lot of reform and a lot of norms developed inside the executive branch since then. I doubt that could happen again, and for another reason, Congress has engaged in reform. So there's been a lot of reform and a lot of concern about that issue in the last 18 years, and it's not something we're focused on.
Thank you.
Yes, hi. I'm not sure. It sounds a little bit like sour grapes. People don't like Trump. Let's take him down. And the reason I say that is the part about making money, I really think that applies to Congress even more than the president. I mean, Congress takes a lot of money from private interest groups and they don't act in our best interest legally when making laws because they favor the people who pay them. You can see that all the time. Taxes, I'd like to know what anyone in government is done tax-wise, not just the president. I think when you say the president, because it's been such an ongoing battle, it sounds like sour grapes because Trump hasn't done it. But I'd like to see your book be more towards politicians because I don't really see a distinguishing difference between a president and the Congress. I think they all have problems, and they all need to get on board. And that would be my suggestion is to take your book because I think a lot of it applies the foreign affiliations. I know some of the people, I think Pelosi has a lot of affiliations with China. So will she enact laws that might prohibit her from getting all that money that she may be making from China? We need to know that as well, much like the president. So I'd like to see this book to be more generic because I think both have the same exact problems. It's just one, we have a president right now who is making it much more, swaying it way to one side, but I think it exists for both.
So the answer to the question is, I mean, we're sort of, to some degree, our mission is defined, which is we're focusing on the presidency. I'd also mention to you, by the way, Congress holds the keys here. And yes, would Congress be wildly enthusiastic about members of Congress releasing their tax returns? I doubt it. However, Congress, once you have this conversation underway, may have to deal with the consequences over time, whether it's a good idea or a bad idea. And I would also point out Congress actually has legislated to create some transparency for their finances, and not too many years ago, enacted financial conflict of interest rules under the so-called Stock Act that was meant to, among other things, for example, limit the ability of members of Congress to use political intelligence of some kind to enhance their ability to prosper in the stock market, say, or with their investments. So the point's well taken. There's a larger problem, generally speaking, people may see with self-interested behavior on politics, on the part of politicians. We're focused on the presidency, and we need to bring the presidency more up to date. The Congress has actually maybe gone even a little farther than so far we have in requiring the kind of accountability that you're concerned about.
So this is a low-hanging fruit-like question. With regard to the subject matter of the book, are you thinking about addressing the ability of the president and the pardon capability? And specifically, if in no other context, the ability of the president to pardon him or herself?
We have a chapter called The Pardon Power, and we have not written one word about it yet. I'll just tell you, it's a very difficult problem. This is really, I don't know if I call it an Achilles heel in Article 2, but that's not the right way of putting it. But the president's pardon power has been recognized by the Supreme Court to be the most robust, arguably the most robust of his powers, and has been pretty aggressive in striking down congressional efforts to regulate the pardon power. We are knocking around ideas. We think we have to address the issue because it's become quite apparent that Trump has been sort of less beholden to norms. Not the first president, but maybe the most aggressive president in his threats to use and his use of the pardon power. And we think we have to address it, but I don't know if you want to add anything to this. We don't yet have it terribly worked out, but it's a very important issue, obviously. I think it's going to grow in importance over the course of this year when he may be pardoning a lot of people, and certainly after, if he does in the fall, you can expect him to use the pardon power very aggressively. One characteristic of Trump is that if there's a discretionary power that he can use in an extreme and norm-breaking way, he'll try to do it. And I mean, that's not true of everything, but so the answer is yes, but we don't have, and I could talk about what we're thinking about, but it's not developed enough to even discuss, but it's a very important issue.
In the discussion that you described, the conflict of interest rules and other similar things, it seems that it all is focusing on strengthening the transparency, if you wish, economic transparency of the president. Well, it all sounds like, in a sense, going to discourage business people from ever entering the government service. In fact, I know of many cases, lower levels of people don't go there because they have to divest from things and such. I think the question is a philosophical one. Is it good, essentially, to encourage only bureaucrats to move into the political system? Because that's what effectively we have been doing for many decades. And this is just going to make it stronger.
So, you know more about this than I do. I'll just say that one of the reasons we think divestiture is not an option, and one that we oppose, is for this reason. And I would also say that our general view, but Bob is more expert on this than I, but our general view is that the problem of both the reality and the appearance of mixing business and public interests and the public duties of the president in conflict with private interests warrants more robust transparency. And it might, I mean, it is a cost. I agree that it is a cost that of this approach, that it will chill at the margins wealthier people with more complicated and elaborate business relationships. It will be a cost on them. But we think that cost is justified by the danger of mixing business and public.
Do you think many of our early presidents would have qualified under this rule?
I'm sorry?
Many of our early presidents probably would be disqualified under this rule.
We're not disqualifying anyone.
Well,
we're not
wouldn't
disqualifying
be willing
anyone
to step up because they have to get rid of stuff.
No.
We're not asking, this is very important. We're not asking anyone to get rid of anything. We reject that approach. We're talking about transparency, not divestiture. That's our basic approach.
Okay, thank you.
But it's a fair point. It's a trade-off.
I have two somewhat very, very related questions. I guess the first question is, which of the proposals that you have do you think would be the most strategic to start with? And which do you think is the most, like, high leverage? Like, which would be the most important if you could only enact one?
Oh, wow.
You want to go first? You want me to go?
Well, I mean, look, there are different ways. We haven't discussed that. We haven't picked our priority list. I can tell you there's one way of looking at it, which is it's going to be very difficult to jump into the most complicated, and so there's a argument for having, shall we say, Congress warm up to the task with the easier ones. If you ask me, is it easier to get Congress started with the release of tax returns or financial interest regulation? Easier to do that than to start regulating war powers? I think the answer is yes, the former more than the latter. I think the fact that it gets going at all is what's impactful. That's what I think is most important, is that there is a commitment to a reform program. However it starts, the initiation of a legitimate reform program that's directed against the presidency, I think, is going to have the wider impact because it suggests that it needs to be high on the American reform agenda. So which one you start with is, really sort of a politically strategic question that I'm not sure how to choose, but I think that the point I'm making about the larger impact of just getting going is that's what I would stress.
And I would just add one thing. A lot of it depends on who the president is and what the Congress looks like. A lot of our proposals are proposals for an enlightened president to make about restraining and reforming the executive branch. That might seem crazy, but it's what happened after Watergate. Gerald Ford and Jimmy Carter, to a great extent, in response to Watergate and some of the other problems in the 70s, they came in very self-consciously in a reform-minded way. Edward Levy, as Attorney General under Gerald Ford, made a lot of important reforms about Attorney General guidelines. That's when the White House contacts policy started getting going to establish norms of independence. I think that the single best thing that could happen would be to get these reforms moving, no matter what the composition of Congress. The easiest way to start making progress, this is a big if, is to have elect a president who comes in understanding that these are serious issues for the country and the presidency, and who's willing to engage in intelligent restraint and reform within the executive branch. And these things can get going over time and be very powerful norms just based inside the executive branch. I mean, a lot of the norms of independence that still prevailed under Trump were non-legal executive branch inculcated norms. And again, you don't know who the president's going to be or what the Congress is going to be, but that's the easiest and quickest way to make progress.
Just a very quick question about the extent of your reforms. You've all mentioned the presidency and occasionally referred to the vice presidency. Would your reforms also apply to, for example, cabinet members? Would they apply to anyone the Senate has to confirm temporally? Would they apply to anyone who declares to be running for one of those higher offices? Do you plan to establish limits, or is this basically something for the presidency and maybe the vice presidency as well?
It depends on the reform. I mean, a lot of the statutes that apply to, I think, correct me if I'm wrong, but a lot of the conflict of interest statutes that apply to lower level executive officials have exclusions for the president and the vice president. Is that right? So there's a reason to focus there because that's where the gap is. A lot of the reforms only concern the president when you're talking about presidential war powers. I mean, you could reform the structure, and we talk about reforming the structure, but the focus is there on the president. I would say that it's a contextual determination depending on what the issue is, but in general, we're focused on the president and his relationship. We have three parts. The first part is about the president and the White House, and the focus there is mostly on the president. We also have a chapter about the White House counsel and what that should look like and how that should be reformed. But it's mostly on the president and his relationships with various issues. The second part of the book is about White House Justice Department relations, and there is a bilateral relationship. So we talk about a lot about DOJ reforms and the relationship there. So it's kind of a contextual answer, but do we go deeper into the executive branch? We tend not to now.
So even the vice president, for example, wouldn't have to put things into trust.
So don't we propose that the vice president?
We do.
Yeah. No, we propose that the vice president do the same thing. So, yeah. So it actually, it's a good question, and we give different answers for different issues because the legal background is different.
Okay, thank you.
It sounds like you don't address things like President taking unilateral action on tariffs and overturning climate agreements and things like that.
No, we do address it.
Do you address it? What's your What's your
Well,
approach?
the climate agreement thing, so we have a chapter called Delegated Authority. And the public lawyers in the room know that the problem of excessive delegation of power from Congress to the president cuts across all the areas of public law and public administration. And we can't deal with all those problems, so we talk about the problem in general terms. In some respects, Trump has not abused this power as much as prior presidents. You mentioned him reversing the climate agreement, but President Obama made that through a very unusual, lawful, but very imaginative way that made it very easy for Trump to legally do that. One of the dangers that Obama ran when he did the Paris Agreement that way was that it would be perfectly simple for the next president to reverse it because it was at its core a political commitment and it depended on regulations. And basically, because Obama was skirting norms by not going to the Congress to get approval for those things, he did so in a lawful way. But the real issue, and this is very complicated, both Obama's being able to make that agreement and Trump's ability to reverse it is really an extraordinary thing if you step back from the constitutional system. The founders clearly believed that there should be joint institutional decision-making for treaties and for congressional executive agreements as well when those developed. And what President Obama's great innovation was he found a way to make international agreements based on something called political commitments, which don't require any congressional statutes. And then he relied on underlying delegated authority. This is getting complicated. But the point is that the whole area of international agreement making has become detached from Congress, and we do have proposed reforms for that. And what was the other issue?
About the tariffs and also unilateral.
So the tariffs, it's a great issue. We mentioned it and discussed it. We don't have reforms that we can't do everything. It's a really important point. I mean, basically, through a combination of Congress has given away the store to the president, all presidents, on control over changing tariffs. The delegation to the president over tariff control is extremely broad and vague, and Trump has exploited it very aggressively to start a global trade war and to change our trade policy on a dime. He supplemented it in ways that people don't appreciate with the emergency power. People focused on the delegated emergency power on the border wall, but that was actually small beans compared to what he did in issuing an emergency order that ended up basically cutting out Huawei from having relationships with American companies. So basically our strategy, because we had to make a prudential judgment about how to get at this, and there's a ton of writing about the problem of excessive delegation and many approaches. We talk about the problem in general. It's actually not something where Trump it's not been his main problem, and we focus especially on the international agreements and on emergency powers. We don't talk in detail about trade.
Thank you.
Wish we had time and space.
Do you have any suggestions on issues around the obstruction of justice and his ability to just ignore any laws that you might put in place and count on the justice system taking too long and taking years or appeals and that kind of stuff to just flaunt the law? So any laws that you put in place, how do you protect that these are actually going to be enforced?
Okay, so when you say obstruction of justice, you mean he just ignores what Congress does,
Yes.
Right?
But just to be clear,
And
you mean he
also-
ignores what Congress's laws as opposed to he does things like to try to interrupt Mueller's investigation to obstruct justice, or do you mean both?
Well, both, and in the impeachment, the issue of he's just not going to use executive power or whatever, and even if it's illegal, just wait until time runs out because you can play with the justice system.
Well, we have some on the first question, and I'll turn that over to Jack. On the first question of the president potentially obstructing the administration of justice as it might affect his or her own legal interests, right, under investigation, that we do have some specific proposals about, and there's some constitutional complexities around preventing the president from basically directing the Department of Justice not to undertake an investigation or directing the Department of Justice to initiate an investigation. But let me just answer the second one first, and then I'll have Jack answer ask Jack to answer the first one. On the second one, this sort of goes a little bit to the whole question, which I think you see playing out in the impeachment process, of political will. what the president did with the House of Representatives in the impeachment process, for example, you seem like you're referring to that, which is you're sending me subpoena. You want witnesses, you can't have witnesses. And if you wanted witnesses, you're going to have to go to court to get the witnesses. That is actually not a form of noncompliance with the law. The president simply invited the Congress to litigate the issue. Now, had a court issued an order, a final order saying, for example, John Bolton must testify, or you, the president, must testify, or whatever, that's unlikely in the latter case, then, of course, the noncompliance with the court order is what you call disregarding the law. Forcing the Congress, trying to force the Congress's hand to play out the clock by saying, I'm not giving you anything that you can't win in a court order, is not compliance with the law. Non-compliance. That's not non-compliance with the law. And the answer to that lies in the impeachment process, and the impeachment process ultimately relies upon a series of judgments that Congress makes about the circumstances in which they can obtain, rely on, and proceed with public support to oust a president from office without an election, right, prior to the term concluding. So I just want to draw that distinction because I thought you were referring to the president saying you can't have what you want. Not quite, I think, noncompliance with the law. Noncompliance with a court order, different story, and would be addressed through the impeachment process. And whether the impeachment process works in that setting is a fundamentally political problem that addresses, that Jack, I think earlier, quite rightly said, depends on kind of where our politics in this country are going. If a president's party says, well, you know what, on balance, we have the majority of the votes in the Congress, and we don't care if the president defies court orders, we have a bigger problem than anything that a legal reform could ever address.
But let me just say something controversial, and then I want to set obstruction of justice aside. Trump has not disregarded law in a formal way by asserting his commander-in-chief power or saying or defying a legal judgment. You remember early on in the first year of his presidency, there was this great concern when the district court started enjoining his immigration executive order. There was panic that he was going to disregard those orders and there was going to be a constitutional crisis. He didn't disregard those orders. He complied with the orders. He is actually much less so than Barack Obama and especially George W. Bush not asserted commander-in-chief power to disregard laws the way they did. He's had signing statements, but so he hasn't done that as much as other presidents. Trump has done a lot of things, and he certainly talks like he wants to break the law, and he encourages people to break the law. But one of the remarkable things, read this volume 2 of the Mueller report, is he can't get people, this is a testament to norms and maybe the application of the obstruction of justice statute to lower level officials. He actually failed to a large degree. We could argue about what's going on right now with Attorney General Bauer, but he failed to a large degree to get people to carry out his orders to violate the law. The obstruction of justice question in particular is very complicated legally and constitutionally. It's complicated legally because there's an open question. People in this room can debate it. There's good arguments on both sides. Whether the obstruction of justice statute even applies to the president, or if it does under current law, what it applies to and what it restricts. There's a constitutional question about the extent to which Congress can regulate the president's exercise of his Article 2 powers, for example, by firing someone or directing a prosecution, to the extent to which they can criminalize that. We have a lot to say about that, and ultimately we think that the first thing that has to be done, because these issues inside the Justice Department are so contested and uncertain, is that, and because it's not clear depending on who you ask in DOJ, Mueller or Barr, whether the obstruction of justice statutes even apply to the president or when, we propose that Congress make explicit when the president can obstruct justice. We think that's a first order priority to make clear what the kind of clear cases of presidential obstruction are. It's not clear that those will be constitutional. They probably won't ever be litigated, but maybe they'll have some impact on norms. And I have to say, again, read volume 2 of the Mueller report. His subordinates, from the White House counsel to political lackeys to appointees in the Justice Department, they wouldn't go along with it either because of norms or because they were worried about obstruction of justice. So, again, I don't want to suggest, but in a weird way, Trump has tried to be lawless. And, of course, there's stuff with regard to the subpoenas and the like, which is kind of typically the way executive branches react, maybe not as extreme as them. He's tried to be lawless, but he hasn't really succeeded. Told you it would be controversial.
Thank you. This is a book I look forward to reading. I want to pick up on something that Professor McConnell said at the outset and pierce the co-authorial veil here a little bit.
Oh.
If you were each to reflect on the book you would have written if you hadn't been writing it with your colleague, what would be different about it? That is, where have you been? What I want to get at is where and how you've been persuaded to include something or emphasize something that wouldn't have naturally occurred to you with your experience in view, but that as you've collaborated together on this project, it's been lifted up for you to include.
Want to take a crack? You want me to take a crack?
Take a crack and I'll follow.
So it's a great question, and we've gotten to know each other a lot better over the course of writing this. For a long time, before we became closer in the course of writing this, we tended to have, we actually wrote a paper. We had an exchange on a question of presidential lawyering in which we disagreed about things. Anyway, to answer your question, several things have happened. A couple of things have happened. One, we've both been at the 40,000-foot level. The fundamental principles that I articulated at the beginning, we agree on. We've had some disagreements along the way, but we've worked every single one of them out. One of us has come up with a more persuasive argument. We've made a few compromises. We've convinced one another of something or another. We've taught each other a lot. We have different expertise and different perspectives. But I'm actually amazed. I don't know what you think. We haven't really talked about this. I'm amazed about the extent to which we've been able to, without much pain at all, to reach consensus on the way we think should go forward. So it's been highly educative for me, and I think hopefully a model for others, because we really have learned from each other, I think.
I think that's right. And I'll just add very briefly, had I proceeded to write this book on my own, it would have been a considerably worse book.
And for me too.
I mean, the fact of the matter is it's just invaluable to have somebody with a different perspective, much deeper learning in some areas of the law than I have, different professional experiences, who, through the process of dialogue, completely enriches and expands my understanding of what both the diagnosis might be and what the reform possibilities might be. And I think that's to me, a very sort of powerful story about the writing of this book.
The same things happened to me, exactly. And I'll also say we also have complementary expertise. I mean, I don't know anything about campaign finance reform, and some of the things I'm expert on, Bob knows less about. So we've been learning from each other on those fronts as well. I have to say, so far, we'll see what the final product looks like, but it's been a thoroughly enjoyable and fruitful collaboration to date.
Yeah, we don't have an appendix yet with dissenting views.
Yeah. I think there's one thing that we disagree on, and that's the OLC opinions about.
Presidential, yeah. With Jack and I do not agree with on the question of whether the Office of Legal Counsel was correct on two occasions to find that a president could not be indicted while in office. I take the view that those opinions are wrong, and though it's a complicated issue, I think Jack comes out the other way. I should mention in that regard, by the way, the other thing that Jack and I just believe very strongly, and this goes to maybe questions we often get about this. The only way to evaluate the strength of the arguments, both in our conversations and for anyone who reads the books, is to engage, and we talk about this a little bit in the first chapter, in an imaginative game of taking Trump out of every hypothetical and putting in Barack Obama. In other words, would your view be the same if a different president were the subject of the topic of the conversation? And that's a discipline, I know as a Democrat, I certainly need that discipline. I think that the value of what we're saying, the coherence and the lasting significance of what we're saying, if there is any significance to it, really depends on the reader just suspending the notion that all of these eagles flow from Donald Trump, and if Donald Trump goes, they go, and this is the biggest problem. And besides all these fabulous powers that Donald Trump has, misused or boasted about or whatever,